members of the commission, staff, and welcome to the September 5th, 2023 meeting of the Stonington Planning and Zoning Commission. We're glad to have everyone here. Let the minutes reflect that the meeting was called to order at 7 o'clock. This evening we have present regular members Ryan Deasy, myself, Gary Belke, Andy Meek, alternates Bennett Bissett, and Ray Philbrick. Seated for the public hearings tonight will be Ryan Deasy, myself, Gary Belke, Andy Meek, and Ben Philbrick. They will also participate in the regular session. The alternates know that they can speak during the public hearings, but during the regular session, input from alternates must cease. So moving on, minutes of August 15th, 2023. Member of the audience, Carlene spoke to me earlier. She has an objection with regard to the way a statement was captured. Ryan Deasy has the alternate language, and unless there are any other motions with regard to, or any other corrections to the minutes, I would like a motion from the commission to approve minutes number 1734 from August 15, 2023.
Mr. Chairman, I make a motion to approve the minutes from August 15, 2023, meeting number 1734, with the updates that Carlene will provide for comments.
Thank you, Ryan. We have a motion to approve. Is there any discussion? Hearing none, all in favor?
Aye.
Anyone opposed?
I will abstain as I was not present.
One abstention. Meeting minutes are approved.
Excuse me, Mr. Chairman, would you like to change the agenda for the public hearings?
Yes, without objection.
When you get to it, or at some
Without
point?
objection, we'd like to reorder the agenda. And under public hearings, we have two items. One is a gas station application. The other is for the construction of a commercial office building. And we expect that the item that's listed first may take quite a while. And as a courtesy to all, we'd like to reorder the agenda and take the commercial office application first. So unless there's an objection, we'll proceed in that order. We had some correspondence from a number of residents on Mason's Island, and it was regarding alleged zoning violations regarding an expansion of St. Edmund's Retreat. And Clifton, I know you have been in discussions with the zoning enforcement staff, so if you could report on the status of that item.
Yes, so as included in the packets, the Planning and Zoning Commission as well as the Department of Planning received a complaint of a zoning violation for the expansion of St. Edmund's Retreat. That is being dealt with by our zoning enforcement official, and a complaint of zoning violation has been filed. That violation is being looked into, and according to the zoning enforcement officer, the response is that there is an intention to remediate the site to resolve the complaint, and that will be responded and fixed in due course. And so there's no exact time frame for that, but that is the anticipation of this moment.
Thank you, Clifton. So I do note I have a copy of the zoning violation, complaint of zoning violation. It was initiated by staff on 8/22. Date of the complaint was 8/7. And it does say that they're going to follow up in mid-September. So if you could report back to us on this after, as a part of your normal report. Prior to the meeting, I believe it's Frank Barco, had spoken to me about this and asked if we were going to read this into the record. I told him that everybody here had read it and thoroughly, and he wanted to read it into the record, and I told him that during the regular course of the meeting it was out of order for citizens to speak. I would, without objection, like to make an exception to allow Frank to make a brief statement, which he requested to do as a courtesy. It's a very well-written complaint, and the history is very helpful. Thank you, Frank.
Thank you, Mr. Chairman, and thank you, members of the commission and staff. We appreciate the time that you're taking with the letter, and obviously I'm not going to bore you with reading it again. It contains a lot of history, and as I think many of you know, there's a lot of history surrounding the activities that have taken place over the years on Enders Island, which residents of Mason's Island have lately has come to their attention. It's the subject of litigation, and it involves a slew of activities. And in addition to the parking lot in question, there's the large parking lot that was originally 27 spaces and is now, I think, over 100 spaces, which is the subject of this letter. And the letter does also contain information about numerous other activities. We appreciate your taking the time, as I said, and my guess is that in the future there will be other things coming before you, and we hope that those will all receive the due process that they're entitled to, both review by staff and if necessary, obtaining special use permits and consistency with zoning. So we appreciate all of that. And if there are any questions, we would be delighted to meet with you and provide you with further information at any time. Thank you.
Thank you. Thank you for the thoughtful letter. I'd like to take a moment of personal privilege here. My first night as the chairman, I do serve as chairman through several other boards and commissions, and one planning and zoning commission and another. But on behalf of the commission, I'd like to extend our sincere thanks and great appreciation for the leadership of Ben Philbrick and the stewardship which he displayed in abundance during his term as chairman. Your service to Stonington upholds the highest standards and traditions of voluntary public service, so thank you.
Thank you.
Okay, zoning enforcement violations, anything other than St. Edmunds?
Nope, nothing at this time.
Thank you, sir. Brings us to our first administrative review item. James Constantine, Greenhaven Shores, Section 2.
I go here.
Please do. If you could speak into the microphone. The only way we have to capture the meeting afterwards, the minutes of the meeting, is the microphone. So if anybody wants to speak, just as Frank did and you're doing now, if you could speak directly into the microphone, it would be very helpful.
Got it.
Thank you.
Yep. So I'm assuming everybody has the application that we submitted.
Yes.
There really is no more detail other than what we submitted. It is, for those of you who are familiar with the end of Riverside Drive, there's a small boat launch and a dock area. And what there's no association or anything, it's just a bunch of neighbors, and it's periodically falls in disrepair, and you can tell by the pictures there's no place to keep kayaks or dinghies or anything like that, so people tend to just lean them up against the wooded area. It's not good for the woods, it's not good for the boats, and all we're seeking is permission to put up two separate racks, one sort of a hitching post type rack to be able to lean dinghies up against, and then a small rack for kayaks, just to make it much more user-friendly and a cleaner, more effective space.
Are these done above the high water line on the shore, or
Yes.
are they part of the dock
Yes.
structure? Okay.
Not part of the docks,
Not part of the
above
dock.
the high water line on the shore, yeah.
Anybody have any questions?
Just out of curiosity, just to confirm, there wouldn't be any additional lighting or anything
Nope.
else? It would just be the racks?
Nope.
Any further questions?
How high is the one with the kayaks on it about?
5 feet?
5?
About 5 feet. Sorry.
And there are no this doesn't impact parking, or it's just on the greenway down?
Yeah, technically, there's really no parking in
Okay.
there. Any people sometimes do, but there's no parking there.
Thank you.
Any report from staff on this?
No, Mr. Chair, I'm just going to read into the record the actual details for the record. So just for everybody in the audience, we're referencing application 23-201 zoning permit. This is for Greenhaven Shores Section 2. And the property is located at map block lot 9-3-DK, and this is in the RC 120 zone, just for the record.
Anyone else have any questions of the applicant?
Mr. Chairman, make a motion to approve the application as submitted.
We have a motion to approve. Is there any discussion? All in favor of the motion?
Aye.
Anyone opposed? Motion passes.
Thank you.
Next item on the agenda is old business. BCMAN LLC, R. Manfredi, bond release reduction, an application for work performed under application PZ1904 SPA and GPP and PZ21232 SPM. Property located at 62 Ballantown Road. Town engineer has commented on this and doesn't have any exceptions. Clifton, is there any other input from the staff on this?
Nope, just to, again, clarify, this is for the full release of an erosion and sedimentation control bond totaling $9,982.50. The town engineer, like you said, offers recommendation for the full bond release as well as the Pawcatuck Fire District Marshal.
Any questions of Clifton?
No?
Any questions on the application?
Mr. Chairman, make a motion to approve the application as submitted for the full release.
Is there a second?
Second.
A motion made and seconded. Any discussion on the motion?
No?
All in favor?
Aye.
Anyone opposed? Motion passes. Next old business item is Daniel and Amy Carlin. Coastal Area Management Review application to accompany a future zoning permit application for the demolition of existing single-family residence and the construction of a new single-family residence. Property located at 264 North Water Street. Mr. DeLuca?
Mr. Hobbert, actually,
Okay.
here for Mr. DeLuca.
Okay, very good.
Just be careful, it doesn't fall too hard. I can get started. For the record, Kyle Hobbert from CLA Engineers.
Welcome.
Here with the applicant, Dan Carlin. As noted in the application, the property is 264 North Water Street. It abuts Lambert Cove. It's a 0.74 acre property with an existing single-family residence on it right now in a garage. It's located in the RM15 zone with a CAM overlay. A portion along the water is also in the RC120 zone. There's no proposed work or activity in that zone. The proposal is to demolish the existing single-family residence. This is the site plan here, located more or less in this area. and construct a new single-family residence and garage in place of the existing residence. The new buildings meet the bulk requirements of the zone. The house is in the floodplain. The finished floor of the building will be located 1 foot above the floodplain as required by the regulations. The garage will be vented to allow floodwaters to pass into the garage. The new structure will be connected to the existing sewer and water services that are on site now that serve the existing residents. The limit of the coastal resource, I don't know if this will come back up, is a concrete retaining wall that abuts, there we go, Lambert Cove along the west side of the property. There's an existing concrete retaining wall. That's the limit of the coastal resource, waterward of that retaining wall. All work on the site will be landward of that retaining wall up in this area here. So there's no proposed work in the resource. That resource is a rocky beach on the water side of the retaining wall. As I said, all work will be uphill of that. The resource will be protected by erosion and sedimentation controls. Silt fence will be provided and installed to protect that resource. And there will be no negative impact to the coastal resource from this development. So if there are any questions, I'd be happy to answer.
This isn't a wave action zone or that sort of thing.
It is not. Everything is beyond that.
So this was sent out to our floodplain manager, SLR International, who does our contracting for flood-related efforts. They reviewed and found no issues with the proposed development. One of the items captured from our zoning enforcement officer is that the RC 120 zone is not captured on the site plan. One of the stipulations added is just to show that delineation on the final site plan. And then staff was still, at the time of writing the report, still awaiting comment from DEEP as well as the town engineer, and so 2 stipulations for modifications to the site development plan be reapproved if necessitated by those comments. Everything else is pretty standard from there on out.
Everyone looked at the recommended stipulation?
Yes.
Have you seen the recommended stipulation?
We have, yes.
Yeah, been agreed.
Yes.
So, this is the only action we're taking here is to approve the coastal area management permit. Any other questions of the applicant?
No.
Hearing none, what's the commission's pleasure on this application?
Mr. Chairman, make a motion to approve the application as submitted with the 5 recommended stipulations that the town planner has recommended. I can read those stipulations into the record. First one, the site plan shall be updated to include the RC 120 zone delineation. Number 2, modifications to the site development plans, if necessitated following Connecticut DEEP comments, shall be reviewed and approved by town staff and the commission as necessary. Number 3, modifications to the site development plans, if necessitated following town engineer comments, shall be reviewed and approved by the town staff and the commission as necessary. Number 4, final site plans shall be reviewed to the satisfaction of the town engineer. And number 5, prior to the issuance of a zoning permit, the final plan shall be signed by the commission and recorded.
I have a motion with 5 stipulations as conditions. Is there a second?
I second the motion.
Motion is made and seconded. Any discussion on the motion? Hearing none, all in favor?
Aye.
Aye.
Anyone opposed? Motion passes.
Thank you very much.
So as I mentioned previously, we're about to go into public hearing. I'll ask Ryan DC to read the notice. Before that, I'd like to say that Ryan, DC, myself, Gary Belkey, Andy Meek, and Ben Filbert will be seated for both public hearing agenda items. So without further ado, if you could read the notice, please.
Pursuant to the general statutes of the state of Connecticut, revision of 1958, and all amendments thereto, and pursuant to the zoning regulations for the town of Stonington, Connecticut, the Planning and Zoning Commission hereby gives notice that it will hold a public hearing at the Stonington Board of Education District Office, 40 Field Street, Pawcatuck, Connecticut, on Tuesday, September 5th, 2023, at 7 p.m. on the following application. PZ 2316 SUP and GPP PRC Holdings LLC D. McKay, special use permit application to permit construction of one-story, 8,220 square foot commercial office building. Proposal includes parking, a subsurface sewage disposal system, stormwater drainage, and associated site work. Property located at 8 Alice Court, Pawcatuck, Assessors Map 18, Block 2, Lot 5E, Zone HI 60.
Thank you, Ryan. Before we begin, I'll explain the process. The applicant will make a presentation. Commission staff will present any comments. Commission will then have an opportunity to ask any questions themselves. Finally, we open it up for public comment. And if you'd like to speak, there's a sign-up sheet by the door. Makes it easier for us to keep a record of who spoke. And we ask that everybody approach the podium and speak clearly into the microphone. Following public comments, the applicant will have an opportunity to offer any rebuttal comment, and we'll go back and forth with rebuttal until everybody is finished speaking. We ask you to be courteous to others and keep your comments as concise as you can to allow time for everyone to speak. So is there someone here representing the applicant? I think I see Attorney Casey here somewhere. I'm sorry, we're going with the second item first. Yes, sir.
Good evening. My name is David McKay with Boundaries LLC.
Sorry, Mr. Chairman, I've been advised we also need to make a motion to reopen the public hearing since this was continued previously.
A motion to reopen the public hearing has been made. Is there a second?
I second the motion.
Is there any comment on the motion? Any discussion? Hearing none. All in favor?
Aye.
Anyone opposed? Sorry about that.
That's all right.
Has to be one glitch on the first night, right?
Good evening. My name is David McKay with Boundaries LLC. I'm here on behalf of PRC Holdings LLC, the owner and applicant of 8 Alice Court. This public hearing was continued from the previous meeting. At our previous meeting, we had a presentation describing the project, going through each sheet of the site plans and the proposed architectural elevations. We discussed the project and how it relates to the special permit impacts listed in the zoning regulations, and we read the requested waivers into the record. Since that meeting, we've provided some correspondence to the town planner withdrawing a request for the waiver of the requirement to provide a legal description, and have provided the requested legal description for the records. And additionally, we were waiting on concurrence from the town engineer on our responses to his comments. He has agreed that we've adequately addressed the comments received, did provide an additional comment that we also addressed, and he's concurred with our response on that comment as well. I'm happy to answer any questions or go back through the site plans if anyone would like to get a refresher on the proposal.
Anyone want to see the site plans again?
No.
We're all had any questions? So, I'm sorry, staff comment.
No additional comment from my end. I'll just clarify that the outstanding comments from the town engineer were responded to, and what is new and included as part of this set is an updated site plans, as well as an updated stormwater management report incorporating that, and so those comments and updates are captured in the report as well.
Appreciate the due diligence in addressing all the town engineer's comments in advance. It makes a lot easier.
Happy that we were able to do that.
Just to be clear, there was a neighbor who has expressed concern about the water sheeting off onto their property.
Yes,
And my understanding is the berm will take care of that, and basically the water is going to be directed, what, in the northeast?
southeast,
Oh, I flipped
very
it.
southeast corner
Yeah,
of the property.
southeast.
Yes,
And so there's no, you're reducing, if anything, the amount sheeting off with the
yes,
basin?
yeah, almost all stormwater will be captured
Great.
and in the stormwater basin discharged at the corner of the property.
Thank you. That's all for me.
Just to be clear, the town engineer has reviewed the stormwater management plan and is satisfied with it, correct?
Yes.
There was a question that the tenant said during the last meeting with regard to when sheet flow was egressing from the site. In this case, water is captured in a berm along the easterly boundary and directed to an existing ditch, existing waterway. The flows are mitigated and those discharges go off the southeast corner directly into water body, correct?
Not directly into the water body, there is about 100 feet or more between the project and the river, but it goes out the very southeast corner. Yes, yes, there is an existing ditch on the southerly property line.
So an existing water flow. Any further questions of the applicant? Okay, hearing none, we'll open it up for public comment. Carly?
Thank you.
Those are old, the top three are old, there's no new.
They're not new people.
Oh, I'm sorry. I apologize. Okay, so just to be clear, these names down here. Oh. Okay. There's nobody signed up. Is there anyone opposed to this application in the audience who would like to speak? Is there anyone opposed who would like to speak? Anyone in favor of the applicant? Anyone in favor? Hearing none, the appropriate motion to close the public hearing is in order.
Mr. Chairman, make a motion to close the public hearing.
Is there a second?
And the motion?
Motion is made and seconded. Any discussion on the motion? Public hearing is closed. Read the notice for the second public hearing.
Oh, we can vote on this one with, we just closed it, yeah.
Fine.
Oh.
Is there a motion? What's the commission's pleasure on this application?
And Mr. Chairman, it looks like we have, if I understand correctly, three things that we need to consider and approve. So I'll make a motion on the first to approve all the waivers that the applicant has requested.
Motion to approve the waivers. Is there a second?
Second.
Second by Mr. Philbrick. Any discussion on the motion? All in favor?
Aye.
Anyone opposed? No one's opposed. The motion passes.
Of the other two? All right. And Mr. Chairman, I make a motion now to also approve the special use permit and the groundwater protection permit as submitted with the three conditions that have been recommended, and I will read out those stipulations. 1, final site plan shall be reviewed to the satisfaction of the town engineer. 2, prior to issuance of a zoning permit, the final plan shall be signed by the commission and recorded. 3, the applicant shall post an erosion and sedimentation control bond prior to the issuance of a zoning permit. The bond shall be either in the form of a certified check or a revocable letter of credit meeting the requirements of ZR 8.6.3. The bond amount shall be established by the town engineer after an estimate of the cost of installing and maintaining appropriate erosion and sedimentation control measures is provided by the applicant and approved by the town engineer. Work shall remain bonded for a minimum of 1 year from the date of zoning compliance.
Motion has been made with stipulations. Is there a second?
Second.
Seconded by Andy Meek. Gary
Gary.
Belke.
All right.
Is there any discussion on the motion?
No?
No?
Hearing no discussion, all in favor?
Aye.
Aye.
Anyone opposed? Motion passes. Now we'll move to the second public hearing. Thank you, sir.
Pursuant to the general state statutes of the state of Connecticut revision of 1958 and all amendments thereto, and pursuant to the zoning regulations of the town of Stonington, Connecticut, the Planning and Zoning Commission hereby gives notice that it will hold a public hearing at the Stonington Board of Education District Office, 40 Field Street, Pawcatuck, Connecticut, on Tuesday, September 5th, 2023, at 7 p.m. on the following application. PZ 2314 SUP, Janet LLC, J. Casey, special use permit application to permit construction of a one-story, 3,300 square foot convenience store with 3 fuel filling stations with a canopy. Proposal includes parking, repaving, stormwater drainage, and associated site work. Property located at 54 South Broad Street, Pawcatuck, Assessors Map 14, Block 2, Lot 6, Zone LS5. To note, this is a continuation from the prior hearing of August 1st.
Do we need a motion to continue the public hearing?
Make a motion to reopen the public hearing.
Seconded.
Second?
Seconded.
Any discussion on the motion? All in favor?
Aye.
Chair votes aye. Anyone opposed? Motion passes. Attorney Casey?
Good evening, Mr. Chairman. For the first time. For the record, my name is John Casey. I'm a partner with the law firm of Robinson & Cole. We represent the applicant, Jeanette LLC. With me is Kyle Hobart, as well as the principal of the applicant, Ahmad Chowdhury, is in the audience with me. This is a continuation of public hearing. As with the first hearing tonight, we don't intend to make our presentation over again. We gave a complete presentation last month. We're happy to put the site plan back up and answer any questions, but we don't want to sort of try the patience of the commission, having already gone through the full site plan, the special permit criteria, and everything else that went with this. So maybe while you think of that, I do have just a couple of items to put in the record, just for clarification. There was a question about the Architectural Design Review Board review for this project. And if you recall, this project first came to you last year. At that time, it had gone through full architectural design review. The design of the building and the basic site design has not changed at all. So it's our position that you have the ADRB's comments on this. I will pass around the minutes from that meeting, so you have them. I also discussed this with the planner, so you could, ask his opinion as well. And then the other thing I want to put into the record is the applicant went around and asked some people in the neighborhood, other people just in the community, as to their opinion. And so we have a petition in favor of the application that's signed by 34 people. And we just, rather than have parade 34 people in front of you saying we are in favor, we thought it'd just be more efficient to provide you a petition so you can see that there is support for this application in the community. So,
Thank you, Attorney Casey.
what I'm providing for you is just the minutes of the last meeting where they where the ADRB made a decision. What I handed to the planner was all 3 minutes, but there's not as much substance in the
Thank you.
first two.
Appreciate it.
As I said, I think we addressed, there was some comments about runoff from the property. I think we addressed those at the last meeting. As Kyle had testified to, this site will manage the stormwater that's produced on the site. It's not going to shed any additional stormwater off the site onto any adjacent properties. And as you know, and in the record, we already have a wetlands approval for this. So the Wetlands Commission has looked at it and found that it's not going to have an adverse impact on the wetland resources. So with that, again, I don't want to gild the lily, I don't want to repeat myself. I have a feeling we'll have an opportunity to talk a little more after the public has had a chance to speak, and we'll address any of those comments at that time. Thank you.
There are no changes between the last application submittal and this time from received by the applicant. The reason for the continuation was just a procedural thing because the updated site plans and from the town engineer or in response to the town engineer's comments just came within the 15-day window prior to that public hearing date. So that's the impetus for the continuation to tonight, but there's no other new information.
The town engineer has now had an opportunity to look at comments, correct?
That's correct. His comments were originally provided on July 2nd, and then he had follow-up comments that were basically stating that what the applicant had provided are sufficient enough, and those were dated on August 1st at the same day that the original the public hearing was first opened.
So the annotation that they're addressed is that he considers them addressed?
Correct.
Okay, thank you. Any other questions from the commission on this application?
Not at the moment.
I have one.
Yes, Andy.
So there's been some discussion about, you know, the stormwater management as it heads towards the wetlands of the property. But one of the neighbors was here at the initial public hearing, and he brought up a concern about stormwater that comes northbound on Route 1, southbound. Yes, comes southbound on Route 1 and enters the property. So I ran up there one of the nice little deluges we've had this summer, and indeed, almost all of the water running down Route 1 enters the property, swirls around where the gas pumps are going to be, and then leaves through the other driveway to go out to a storm, a catchment basin on the street. So I was just wondering if you could refresh my memory. I wasn't sure how that was going to be handled in the stormwater management plan. You just indicated that all water on site will be dealt with, but I'd just like to clarify, for the neighbor's sake and for everybody's sake, that water that can enter the property as it comes down Route 1 is also going to be able to be handled or prevented from entering the site.
Again, Kyle Hobbert from CLA Engineers. That water does come down Route 1 and kind of curves into the site and then leaves the site. The proposed site is graded so that the driveway aprons from the property will keep that stormwater on Route 1 that's generated on Route 1 in Route 1 and continue bypassing the property.
Great, fantastic, thank you.
Not the ones with checks.
Okay, so these people, got it.
Mr. Chairman, if I may, I have a question for the applicant. If I may, and I looked on the site plans that you provided, and I know it's described, but I don't see it kind of visually. I just want to confirm that the signage, especially since you're going to have a no left turn for one direction, that all of that signage would be in accordance with Department of Transportation, and I mean, it's going to be legal signage, brightly lit, because my concern is when I drove by here, coming here tonight, it jumps up on you kind of quick, and you've got a whole bunch of signs with people, and my concern is you have tourists that go, and are they going to know it's not a left turn here, but it's a left turn down here? I want to make sure the signage is as robust as possible to prevent confusion.
Yes, all the signage will be in accordance with the DOT standards and regulations. DOT's only comment to us was to add an additional no left turn sign in the town in the right of way. So there will now be 2 no left turn signs in the right of way. So it's clearly demarked that there's no left turns into the site. But all that signage will be in accordance with DOT regulations and as part of the encroachment permit through DOT.
Okay, thank you.
Thank you, sir. Any other questions from the commission?
I had one more question too. I think you had said the tanker deliveries were going to be after 12 a.m. Is that common? And also, they could only pull in one way into the site, I think. Is that common as well, and can that be enforced?
It is, tanker trucks generally deliver to the same sites and know their ways around and how to access the sites. So yes, they will be familiar with the site and know the traffic patterns of the site. I know deliveries, fuel deliveries are done overnight, off hours, and that kind of stuff. I don't know how common it is, but it does happen, yes.
Okay, thank you.
Any further questions of the applicant?
And those times, Gary, are included as stipulation number 8.
Thank you, Clifton. Clifton, any further comments? No?
No comment.
Okay. We'll move to public input. And the first name on the list is Attorney Chase. Evening, sir.
Good evening, Mr. Chairman, Commission members, and others. Excuse me. For the record, John Chase, representing Alden Associates Limited Partnership, which owns and operates a business at 60 South Broad Street, just down the road from the subject property. I have with me tonight, and in an effort to provide a little bit of a structure to my presentation, I'd like to explain who I've brought with me tonight, for what reasons I've brought those witnesses here, and then proceed to their particular presentations and some comments on my part. Before I quite move to there, I took a few notes during the small additional presentation that Attorney Casey made a few moments ago to follow up his presentation last month. It's important, I think, that he noted that he was not intending to try the patience of the commission by presenting further material that's already been presented. I'm afraid I may try your patience, and I apologize in advance, but I do have quite a bit of material, and as you all know, it's important for purposes of the creation of an administrative record that this material be properly brought in, both in terms of oral presentations and written documents. I would also note, and I found it interesting, that apparently a petition was presented, signed by some 34 people reportedly in favor of this application. And I would simply note for the record that of the 2 or 3 folks who spoke at some length in opposition to this application last month, that neither I nor, as far as I know, my client had anything to do with bringing those people in or asking them to speak, and that as far as I know, they spoke entirely of their own volition in raising their concerns. As I said, I brought with me tonight several witnesses. One I believe you've met before, and that's Mark Temple over here on the left side of the room. Last time he appeared before you, Mark Temple was principal of Lennard Engineering. He's now with a firm known as Haley Ward, a larger New England-wide engineering firm. And with him is Dave Batista, who is an engineer with that firm, who has reviewed the application and is prepared to submit his written review and to speak to that. Mr. Temple is here also to be available for follow-up comments and any rebuttals within his particular areas of expertise and knowledge. I also have with me tonight at the rear of the room John McNeil. John is the Director of Facilities and Construction for Alden Associates Limited Partnership. And he's going to speak to several aspects that of this application, several issues that have been addressed either in the past or more particularly with relevance to what was presented last time, and perhaps some additional comments as well. I do have, and it gives me no great pleasure, I should say, to bring this to the Commission's attention. But as you all know, or I believe are aware, that as an attorney, I have a right, or rather a responsibility, to represent the legal interests of my client diligently and to raise points that, may be concerning, perhaps, in terms of the need to do so, but nevertheless are not intended to be critical of anyone in so doing. Again, this is done for the record and to bring issues to the attention of the Commission. But earlier in your meeting tonight, one of the neighbors, I believe, on the St. Edmunds retreat issue expressed great concern that the Commission follow due process in the future with respect to matters arising in connection with that issue. And on that same point, I unfortunately need to bring to your attention some comments which appear in the town planner's report for this meeting under this subject heading. I again want to make very clear that I have communicated with Mr. Eiler in the short time I've known him. I think I have a good professional relationship with him, and I don't raise these for any particular personal or purpose or any reason to cause any embarrassment. But drawing attention to his town planner comments, he states that the Commission may be familiar with a variation of this application, and he cites an earlier application number which went to public hearing but was withdrawn last year. He says one of the key questions at that time was whether the former gas station was legally abandoned by the previous owner when the fuel tanks were removed and the roofing business was opened at this location. And then in parenthesis, he goes on to say, this would exempt the applicant from complying with zoning regulation 2.11.2 regarding distance requirements from other gas stations. And then he makes the further statement that in a memorandum dated July 16th, 2022, the town planner advised that the case law would suggest abandonment had not occurred. Now, to unpack this, I'm simply going to start by saying that we, my clients and certainly I, disagree in no uncertain terms with these two statements. One, that the issue of abandonment has anything at all to do with zoning regulation 2.11.2. And secondly, that in the July 16, 2022 memorandum that the town planner wrote concerning a different application, that the town planner, although it involved the same property to be sure, that the town planner reached any legal conclusion whatsoever on the issue of abandonment. I think he did a pretty fair job outlining what the general law on the subject is. He cited to a couple of case decisions. Unfortunately, he didn't provide the citations or the name of the cases, but the principles that were addressed by the courts in those cases are familiar enough. But one may search in vain through Attorney Londrigan's letter to see, dated last year, July of last year, to see anything at all to do with zoning regulation 2.11.2 or anything to do with the subject of the case law suggests that abandonment had not occurred. Now, I note for the record that Attorney Londrigan's July 2022 letter and some other materials on the subject of abandonment are already exhibits to this meeting. They were submitted to you by Attorney Casey last month. So I'm certainly not going to repeat that, or rather, provide additional copies unnecessarily. I do want to provide, again, for purposes of keeping the record, making the record complete in this matter and on this subject, I'm going to ask that to the extent these are not already part of the record, that the report of the town planner for this meeting, or the meeting summary report as it's entitled, and also an email that I received, as each and every one of you did last Friday, attaching a copy of this report, be made a part of the record for this meeting. For that purpose, as two separate exhibits, I guess, would be appropriate. And although this is not a court of law, and although the rules concerning the conduct of administrative agencies such as yours are relaxed from those that would apply in a court of law, nevertheless, I'm struck by a couple of familiar expressions that would apply in a situation like this. That is to say, in a situation where this commission, who I have, and to be clear, every reason to believe is comprised of fair-minded people, nevertheless have been presented with something from the town attorney that's been characterized on 2 points as legal advice that would compel a particular result. Certainly, I believe all of you are under the reasonable impression that you are to give due weight to the guidance of your town attorney. That's certainly natural. And where, however, the letter in question simply does not say the things that it's purported to, I find myself going back to expressions, as I said a moment ago, things like, the jury will disregard that last statement. Or, as we say sometimes in legal practice, how do we now unring the bell? For purposes of maintaining the concerns that courts have repeatedly expressed toward due process in proceedings like this, and more particularly under the specific title or type of due process that's referred to as fundamental fairness, I think that the Commission needs to make note of this circumstance, this situation, and decide how it would like to proceed. What the courts have said on the subject of, what the Connecticut courts have said on the subject of fundamental fairness, is that the decisions of local boards will not be disturbed, that's to say on review in court, as long as honest judgment has been reasonably and fairly made after a full hearing. Now, as I note here, and as I think we're all aware, I'm appearing on behalf of my client, in effect, for the first time. Last month I had the opportunity to speak but chose not to because the hearing was continued. So, to say, before all of the evidence has been presented, before a full hearing has occurred, that the town attorney's letter written a year ago somehow compels this commission to reach particular conclusions of law on 2 distinct, albeit related subjects, I think is a serious due process issue and question. The courts have further said, in reviewing the challenged conduct of public officials, fairness and impartiality are fundamental. That was in a case called Berry versus Historic District Commission in the Connecticut Appellate Court. The first decision I quoted from was also part of, part of the Berry decision as well. And so I would put it to the commission, can you now unring the bell? Can you now disregard legal advice presented as such that does not say what it's purported to say, and you can review yourself the letter that was written by the town attorney last year because it's now part of the record. You may want to further consult with him on this subject. But if you can't ring the bell, if the jury, as it were, can't disregard the information that's been presented suggesting that it should reach a particular legal conclusion based on what the town attorney has said before it's even heard all the evidence, then I think I have to ask the commission if now would be an appropriate time, before we use a great deal of anyone else's further time and resources, to deny this application without prejudice to the applicant to resubmit it, to come immediately back before you on a new public hearing that does not contain this due process issue, does not contain this instruction, this guidance to reach a particular legal result on an issue that we know is significant, and as the town planner in fact has pointed out, was a key question that was raised a year ago and was presented, I think, again to you upon the same letter, same materials prepared by the applicant's former attorney, same affidavit, same analysis that, in fact, was presented to you just last month here. Now, I don't know that you're able to make that decision at this time. It may be that continuing this hearing would be an appropriate way of seeking guidance from your attorney as to what he actually meant to say. I don't think he would say that, you know, go ahead and deny this without hearing all the evidence. Go ahead and deny this upon something that, in fact, his letter doesn't say. But I leave that to the commission, and am prepared to continue on tonight, but would like the commission, as part of its decision, to address those issues, or to do so now if it feels appropriate.
If I may, just, Mr. Chair, I have full confidence in our town planner. I fully understand he's not a lawyer. I have fully read more than once, if not a half a dozen times, Attorney Lonergan's July 16th, 2022 conclusions. And I think he mentions that if evidence can be brought up that it was never abandoned, then we can proceed.
Anyone else care to comment? I think you can proceed.
Thank you, Mr. Chairman. Thank you, thank you, members.
That's not to say that we may not reach a conclusion later on, that we want to talk to our lawyer before we
I certainly understand that, and I
We have those patients.
appreciate your candor, and I also appreciate your understanding that sometimes I need to raise something for the record. And again, it's not not something I do with pleasure.
Again, for anything you're doing, I think you're making a thoughtful presentation, and that's the way to do it.
Thank you, Mr. Chairman. I really do appreciate that. So, as I said, I have with me several witnesses, and I'd like to first call to the lectern Dave Batista, who I believe not only has brought with him copies of a written report he's prepared, but if I'm not mistaken, also copies of his professional resume. And I'd like to ask Mr. Batista to speak for himself.
Good evening, Mr. Chairman, commission members, staff, and applicant representatives. My name is David Batista. I'm a licensed professional engineer in Connecticut. I'm employed by Haley Ward Incorporated, general civil engineering firm with offices throughout New England and Florida. My colleague Mark Temple is passing out a letter that I would like to be made part of the record, dated July 28th. It's addressed to the Stonington Planning and Zoning Commission, and it regards this application. In the sake of expediency, I'll summarize this letter. You can read it and you can ask me any questions if you see anything while I'm summarizing it. But the first page and a half are just a list of the documents that I reviewed that were part of the application. I won't belabor you with the list of those. My comments, technical comments, start about a third of the way down page 2. And the first two relate to the soil erosion and sediment control plan. These are technical nut and bolt comments that I don't think the commission needs to spend any time on. If you glance over them and have questions, I'd be happy to answer. Moving on to item 3, I state that table 7.10.4.4 of the zoning regulations requires 16.5 spaces for the 3,300 square feet of gross retail building that is proposed in this application. The parking table count on sheet 2 of the site plan set states that there are 17 spaces provided. If you count the parking spaces on the site plan, there are 11, 9 in front of the building, 2 out near the landscape frontage, and so presumably they're counting additional spaces at the fuel dispenser berths as parking spaces, which would bring the total to 17 as acknowledged in their table. And this presumes that fueling berth or fuel dispenser berth parking spaces are valid off-street parking spaces in accordance with your regulations. In our opinion, the convenience store and the gasoline sales components on this site are separate uses that might be expected to share many of the same customers. We've all been to these places. And if so, then the peak demand hours for each use would be coincident, thus giving rise to the potential for deficient parking during times of peak demand. Section 7.10.2.5 of the zoning regulations requires a special use permit for individual uses occupying the same property. When I reviewed the application, I did not see any separate application for such a special use permit, nor any discussion of the issue in the present special use permit application, which was dated June 20, 2023. So I believe that the Commission should require the applicant to apply for a special use permit for shared parking under 7.10.2.5 in order to allow yourselves to consider the specific information required under that section before determining whether criteria for approval of shared parking is demonstrated. I go on to say, moreover, without such a determination of whether or not the requirements for a special use permit for shared parking under that section have been satisfied, the Commission would lack critical information in deciding, for the purpose of present application, whether or not Section 7.10.2.5, the fuel dispenser berths, can be counted as parking spaces. Comment number 4, I talk about the on sheet 4 of the site plan set, shows sight lines for intersection sight distance at the exit, which is now a right turn only heading northbound onto Route 1. The westerly sight line, looking back at traffic coming at you as you're trying to get out, passes through or very close to the freestanding sign that's there right now. I think it was mentioned by one of the Commission members earlier. And that sign is scheduled to remain. There's no detail showing how that sign might be modified or configured for the new business. In addition, there's a new pole-mounted luminaire that's scheduled for placement immediately adjacent to the freestanding sign. I believe it's on the gas station or convenience store side of the sign. And then there's a utility pole just west of the freestanding sign, a little bit closer to Route 1. So when you consider those collectively, in addition to the vegetation that will be planted there, which on the site plan shows a mature height of 3 feet, the potential for sightline obstruction is there. We ask that you ask the applicant to address that technical concern and provide a detail of the sign so you can make sure that the panels of the new sign don't hang down too low and block views of oncoming traffic. I forget the exact number for sight distance at that location, but it's probably somewhere in the magnitude of 445 feet, if I remember correctly. That's a long distance, and it's not just one line. You need to see up and down, and there are tests for the sight line measurements, which the engineer and I are both very familiar with. In addition to that, Section 14-332-5 of the regulations of the Connecticut State Agency stipulates that permanent or movable signs that in any way obstruct the view of the driveway at a retail gasoline station are prohibited. So there's a state regulation that specifically prohibits signs that could obstruct the sight distance. So therefore, we recommend that you ask the applicant to provide a detail of the proposed sign to demonstrate that the collective obstacles will not impede safe intersection sight distance and that the design complies with the aforementioned regulation of the state of Connecticut. And also provide a maintenance plan for vegetation and the frontage landscape strip so that it doesn't grow up into the sight line the line of sight for people trying to get out. Number 5, the design engineers issued a letter to the Planning and Zoning Commission dated July 24th, in which they responded to review comments by the DOT. And I note that one of the comments, DOT asked them to enlarge one of the openings for one of the curb cuts, and instead of doing that, they chose to make the site one way in. Northbound traffic on Route 1 can turn in. Northbound traffic leaving the site can turn out. There are some no left turn signs proposed on the southbound side of South Broad Street to prohibit left turns into the site. I perceive this as an unresolved comment with DOT, and I recommend that the Commission require the applicant to review the proposed change with District 2 of ConnDOT to provide evidence that change is an acceptable thing to the Department of Transportation. I have to deal with this kind of stuff all the time myself, doing similar projects to Mr. Hopper, and you know, it's sort of a paradox that DOT doesn't like to issue approvals until there's town approval, but yet their conditions could really alter a site plan significantly if they have conditions that are not consistent with the way the site would be used. So I'm asking you to look into that as commission members. And I also think that southbound customers on Route 1 are going to ignore the prohibition of left turn because they have mountable concrete islands to allow trucks to turn into and out of the site, and people are just going to be making that turn. I see it all the time in sites, driving around in my experience and thinking about how that site was designed and watching people violate the no left turn. Under 5B on the top of page 4, there was a grade beam that the town engineer asked for in his review of July 2, and I don't see that on the revised plan. There are some stop and no left turn signs on each side of the exit driveway to warn people trying to leave the site not to turn left. There are signs, the position of those signs are shown on the right side of the driver leaving the site, but they're not shown on the left side. And that's because there's no good place to put those signs. The turning movements for the trucks, if you look at the turning movements on sheet 4, you'll see the wheel paths of large vehicles trying to get in and out of that site. The sign would have to be way over to the left and would actually fall behind a proposed parking spot. I do note on number 7 that the turning template for the fuel delivery truck encroaches on 2 fuel dispenser berths and 5 parking spaces in the front of the convenience store. I did hear the conversation about limiting the hours of use or delivery of fuel. That is something that's up to the commission. Perhaps my colleague Mark Temple will decide to talk more about that, but if they run out of fuel in the middle of the day and need to take a delivery, there's going to be some chaos in that site. It won't work. I also mentioned on number 8 that the turning template, there's no turning template for the movement of a refuse truck to come in and pick up at the dumpster. The truck's final approach to the dumpster has to more or less line straight up, perpendicular with the dumpster. The forks have to go basically straight in, and if there's a car parked at the most easterly fuel dispenser berth when that truck arrives, there's going to be, again, something's not going to work correctly. I noted in number 9 that 7.10.6.2 of the zoning regulations requires that all off-street parking areas, with the exception of single-family duplexes and triplexes, shall provide a minimum of 20 square feet of interior landscaping for each space. Thus, you would need 340 square feet per regulation. I don't see any interior landscaping proposed on the site plan. Although the term interior is not really well defined, it's hard to say exactly what the regulations mean, but I raised the comment. In item 10 of my letter, there's some criteria that the commission must follow in making a decision. The first one that I cite here, 6.4.1 from your regulation, is that site will be adequately served by water and sewer. I'm recommending that the commission get some kind of assurance before you make a decision that the water and sewer services are feasible, given the new use on this property. The second condition I cite is that the transportation services are adequate. No undue traffic generation will result that would cause a deleterious effect on the local welfare or safety of the motoring public. I won't elaborate, but I brought back up the DOT issues. It's pretty much a public safety issue, getting cars in and out of this site. And because there isn't a DOT approval, it's hard for the commission to make sure that DOT would be completely acceptable with the way things are configured now. And lastly, I cite 6.4.7 of your regulations that all applicable regulations, state, federal, and local, have been complied with, satisfying all design, procedural, and review requirements. During the wetlands approval for this project, I submitted 2 letters to the commission. The first one was in April, the second one in May, where we had gone around and around a couple times with the applicant and the commission about concerns I raised about drainage. So I've submitted a copy in the packet that we handed out, a copy of my May 4th letter to the Wetlands Commission, in which I raised significant concerns about the stormwater management design, compliance with the 2004 Connecticut Stormwater Quality Manual, and the Wetlands Commission decided to approve the project without asking the applicant to address that concern. Your commission does have jurisdiction on drainage issues under section 7.13 and section 8.4.2.6 of the zoning regulations, and I ask you to enter my May 4th letter into the public record of this hearing, and that you consider the findings and recommendations that I made in that letter as you decide on this project. Those are all the comments I had. I'd be happy to answer any questions while the commission has me up here, or I can come back later if there are any specific questions. Thank you.
Mr. Chairman, John Casey for the record. Can I ask one question of Mr. Batista while he's here? Your letter is dated July 28th.
Yes, sir.
Is there a reason why it's only being submitted to the commission tonight when we opened this hearing a month ago?
I don't know. I turned this letter into Attorney Chase, and perhaps he could answer that question.
Thank you.
Thanks, Mr. Chairman. For the record again, John Chase. And thank you, Mr. Batista. Just for clarification for the commission, on a couple of the comments made by Mr. Batista on the application. He spoke of the shared on-site parking regulation, and he said, I believe he used the word in his opinion, there are 2 separate uses being proposed here. Well, in fact, well, I certainly concur with such an opinion. It's in fact specifically indicated in your regulations that is the case. Section 4.3 of your regulations for the local shopping or LS5 district state, or rather list at 4.3.1 the permitted uses in the district, of which 4.3.1.8 specifies retail or wholesale sales buildings less than 5,000 square feet gross floor area. And then at 4.3.3, that portion of your regulations lists uses allowed by special permit in the LS5 zone, which include at 4.3.3.6 gas/auto service stations. So it's the regulations themselves that define these as 2 separate uses, therefore invoking the shared parking requirement that Mr. Batista referred to, or the shared parking regulations at 7.10.2.5 that provide that this can be allowed by the commission, can be authorized by the commission by special permit. In other words, the concurrent use of spaces, parking spaces for two different uses where certain conditions are satisfied, and they're listed at length under 7.10.2.5. But again, as Mr. Batista said, he saw no separate special permit application for shared use, shared on-site parking rather. I saw no separate application in the application file, which I've reviewed several times. Certainly the notice for the public meeting, the publication of that notice, none of them have specified that what's being sought from the commission now includes a separate special permit for shared on-site parking. And I would submit that until the applicant can demonstrate that it's received a special permit for that purpose in satisfying of all of those requirements in 7.10.2.5, then this commission cannot approve this application. It might have been possible to apply concurrently, but again, this hearing has been noticed and opened for the purpose of the application as it's presented, not for an entirely different special use permit application. And again, likewise, for reasons listed in several of Mr. Batista's comments, the familiar shall I say, expression or the familiar position of a commission in circumstances where compliance with all of the required regulations has not been demonstrated is clear. It could either continue the application or continue the hearing for compliance with those regulations where possible, certainly not in the case where a separate application for a special use permit is required. But with regard to things like the interior landscaping provision that Mr. Batista highlighted under 7.10.6.2, perhaps the commission would like to afford the applicant additional time to demonstrate compliance with that. He also noted that section 6.4.7 of your regulations requires that, and I quote, all applicable regulations, state, federal, and local, have been complied with, satisfying all design, procedural, and review requirements. In other words, an applicant must demonstrate to you that all such applicable state, federal, and local regulations have been complied with. And one thing that I have not seen any demonstration of compliance with is this. Mr. Batista did quote from and identified one portion of the regulations of Connecticut state agencies. And again, this would come under the heading of demonstrating compliance with all local, state, and federal applicable regulations. What he did not address, simply because there's been no demonstration whatsoever that there has been compliance or even consideration of this, is section 14.332-4. That's, I should say, 14-332-4 of the regulations of Connecticut state agencies. This pertains to parking of motor vehicles at retail gasoline stations. And it says, parking of any motor vehicle at a retail gasoline station on a state highway, which is what we have here, obviously, Route 1, is prohibited if such parked vehicle in any way obstructs the view of vehicle operators entering or leaving the driveways of such location. Now, what we've seen in the site plans, which are not up on a screen, but I think you're generally familiar, is that I believe two of the parking spaces, in satisfaction of the requirement that so many be provided, or at least in an attempt to satisfy the shared requirement without applying for the requisite special permit. In any case, those plans show, I believe, two, maybe three spaces situated right along Route 1, in other words, on the inside of that landscape strip. The more important thing, of course, being not that they are along Route 1, but that the gas station is located along Route 1. And what I'm concerned with here is that the commission has nothing demonstrating the impact on or rather demonstrating that a parked vehicle in those locations does not in any way obstruct the view of vehicle operators entering or leaving the driveways of such location. What if it's a giant pickup truck parked in one of those spots, or a box truck, like a rental van or something like that, or a moving vehicle? One could easily, and I'm not speaking from a technical perspective, mind you, one could easily imagine that there would be much greater impact of a vehicle of those calibers parked in those locations than, for example, a compact car. But there's been no analysis under 14-332-4, and that's the concern that I raise. Because as indicated, your regulations require demonstration of compliance with all applicable state, local, and federal regulations. I've passed around copies of that portion of the regulations of Connecticut state agencies and asked that that be made part of the record also. And now I'm going to call to the lectern Mr. Temple, Mark Temple, who some of you may recall from a past presentation. Mr. Temple has many years of experience in the gasoline station industry, one might say, and I'll ask him to further characterize that, but also to speak to some of the points that were raised by both the applicant's presentation that he witnessed last month and also by what he's heard so far tonight.
Thank you, John. Excuse me, Mark Temple, Vice President Haley Ward, 2210 Main Street, Glastonbury. I'm here to discuss, hopefully briefly, some of the concerns that we have with regard to this development. I think the first concern is one that was extensively discussed at inland, a number of inland wetlands, and that's the issue of deliveries. As John indicated, first of all, I'm a licensed environmental professional in Connecticut. I forgot to note that, and I've been working on gas stations for 38 years. That's primarily what I do. And one of the real concerns that we raised at the time of the prior site plans was this issue over line of sight, right? The gasoline underground storage tanks are located directly between the building and the first dispenser. And the only way for the haulers to come in there and drop fuel to those tanks was to park either right on top or forward closer to the building so that they connect hoses to those tanks to deliver their fuel. And when you're doing that, you now have a 9 or a 10-foot tall tanker that separates, right, the building from the dispensers, and I think the fire code says that's not allowed. You have to be able, the operator at the station has to be allowed to see those dispensers. Ultimately, the applicant, and we also talked about turning movements, that if there were occupied parking spots, there was no way for a tanker truck to get in and out of that site. And I think the applicant took those issues to heart and came back ultimately and said, as I think was relayed earlier tonight, that deliveries were going to occur after the station is closed. So sometime between midnight and I think 6 a.m. is proposed, is when these deliveries are going to occur. So my question to you is that, okay, now we have deliveries between midnight and 6 a.m. Are all the lights going to be left on for that 12 to 6 a.m. period? It's dark, right? We're talking about delivering fuel. We just had, probably all of you know, a rollover on I-84. There was a rollover in Norfolk, one that I'm working on. You know, it's a very dangerous business. Fuel is very combustible. And I would suggest to you that deliveries after midnight but before 6 a.m. are going to be inherently dangerous, because I haven't heard yet how the site is going to be lit. So I think lighting for deliveries is an issue, and I think one that you need to address. My second issue is that I renew our argument about runoff from the site. Currently, there's no vehicles parked on the property. There's very little runoff, and the runoff that's there has probably already picked up any of the contaminants that are in the superficial soils that are running into the wetland. So I would suspect that the contaminant load is very low. But once this site gets redeveloped, the applicant would love to have 50,000 cars in there every day, all parked right in front of the store, right? Because the margins on gasoline are not very good, but margins on coffee and anything else that you buy in the store are much, much better. That's why the store is the centerpiece of this application, right? The margins in the store, remember this, the margins in the store are significant compared to gasoline. So the applicant wants as many cars to come in and out of that site as possible. We're going to have drip leaks on many of those cars. The age of cars now in the United States is some 11 to 12 years old. It's the oldest it's ever been. They all drip, right? We're going to have fuel dispenser leaks that occur at the dispensers. Part of what I do is clean those up. They happen at every gas station. All of that, well, some of that will ultimately run off with rainfall, and the applicant has suggested that, of course, it's all going to run to the catch basin, and it's going to migrate, flow from the catch basin to the vortechnic unit. But that vortechnic unit is only going to remove the floating phase. Right? So that sheen that you see, heaven forbid, the spill of 50 gallons that gets into that vortechnic unit, that 50 gallons will be contained so that they can pump it out. But during that period, there's going to be substantial solubility. The contaminants are going to solubilize into that rainwater runoff, and they're going to flow right through that system. There's nothing in that system that removes dissolved phase contaminants. So you're going to have both aromatic and polynuclear aromatic hydrocarbons that are going to flow right through right through the system and ultimately into that wetland system, and that wetland system flows behind the Alton Associates property, which is about 120 feet down gradient. So I continue to raise that concern because it's been dismissed. It's been dismissed by the applicant. It's been somewhat dismissed, I think, by the Inland Wetlands Agency. And it's part of your review is drainage. And I'm letting you know that one of the problems with a very active gas station is spills that go to the pavement, that we ultimately then have rainfall. We'll see these contaminants dissolve into that water, and they will migrate right through the system. It's not going to inhibit that migration at all, and those contaminants will then be in that wetland system. The applicant has said there's no impact to the wetland. I'm here to testify there absolutely will be. Those petroleum hydrocarbons, whether aromatics or polynuclear, will be in that wetland system as a result of this development. I'd be happy to answer any questions. Thank you.
Do you think we should be talking about a catch basin with, should we be talking about a catch basin at some point that could infiltrate?
I think the town engineer has reviewed the drainage plan. I guess when we get all done here, we can talk about whether or not we want to raise any of these additional issues that have been raised by two engineers and a facilities manager to the staff. There are zoning issues and there are technical issues that relate to the site plan. You know, we've heard of zoning issues that are permitted uses, you know, shared parking. We've heard technical issues with respect to dumpsters, sight line, pole obstructions, potential replanting of the landscaping, an unresolved comment with CONDOT, and whether or not we have water and sewer approval, which I think we do have. But, so yes, in answer to your question, I think we need to have a discussion as to whether stormwater management is adequate or whether an additional catch basin, with some type of control on it, is appropriate.
Thank you.
So Attorney Chase, do you have another witness, I believe?
I do,
Who's
Mr.
signed up on our sheet?
I do, and he is, Mr. Chairman. His name is John McNeil, but before I call him up, I would like to provide a little bit of context. As I said earlier, Mr. McNeil is Director of Facilities and Construction for Alden Associates Limited Partnership. And I want to, I should first say that I'm not trying to be coy in this respect. Everyone knows that, I think at this point in the proceedings, that my client, Alden Associates, is a gas station operator, and they operate a gas station just down the street. And that's the context of some questions I have for Mr. McNeil, but I wanted to first address something that I did in sort of an oblique way earlier, and that is the issue of abandonment in and of itself, and the relationship of the concept of legal abandonment of a use to your regulation concerning gas station distance requirements at section 2.11, I believe. Just for the assistance of everyone, I'm not sure if the site plan contains a general location map, and so I've printed out some copies of maps from your town website that show the relationship of the various properties, and I think those will be helpful, and they're also in for another more particular reason that I'll explain in a moment. I'd ask that those map packages, and I guess I should further clarify that the facility for printing out maps from the town website doesn't necessarily allow inclusion of all portions at once, and so this package contains, I believe, 4 maps, all of which are intended to show the relationship of the subject property at 54 South Broad Street to my client's property at 60 South Broad Street. And you'll see that they are separated by the property at 56 South Broad Street, and then the maps indicate that that distance, that separation distance, is about 150 feet. And my only point in really noting that at this point, at this time, is to note that your regulations, of course, contain at, I thought I was right, 2.11, a regulation that says, 2.11.2 more specifically, no gasoline or diesel filling station or automotive service or repair station shall be erected within a 1,500-foot radius of any part of any lot used for these purposes. Now, as part of that particular I'll call it regulatory scheme in 2.11. There's also a separate regulation concerning the location of gas pump or diesel filling appliances within so many feet of a street or a rear lot line, and we don't contest that that this time around the site plan complies with that requirement. But as far as 2.11.2 goes, the maps I've just submitted show a distance between 56 and 60 South Broad Street that's about a tenth of that requirement, that 1,500-foot separation distance specified in the regulations. Now, that regulation seems straightforward enough, but last time I was before you, last time this applicant was before you in regard to this property, somehow the issue, I believe it could be fairly said, became conflated with the issue of abandonment of zoning uses. Attorney Casey submitted last month a package of materials that was actually prepared by Attorney Cole, the attorney who represented the applicant a year ago before you. And there's a lengthy letter on the subject of abandonment of zoning uses and the importance of intent of a property owner at the time of some event, which is later held or purported to constitute abandonment. And there was even an affidavit submitted last year, which was resubmitted last month, that was sworn out by someone who worked with a company that apparently sold the property to the present applicant. And of course, as Commission Member Conway, who's not here tonight, pointed out, I distinctly recall, her commenting that the issue is really what happened 8 or 10 years ago when the gasoline tanks were removed by a prior owner and what his intention might have been. And so I'm sort of glad that we're not in the business of trying to guess at this point what someone who is not in the room and has submitted no testimony actually intended at the time, because that would be the relevant determination for purposes of an abandonment analysis. And I think the town attorney's letter of a year ago gets to that point. But your regulations, I think, make very clear that the issue of abandonment could really be said to be something of a red herring. Your regulations I hope I haven't handed in a page of my notes with, oh, here it is, I'm sorry, with that last exhibit. Your regulations provide at 2.6.2, under the heading of abandonment and discontinuance, that any nonconforming use which has been abandoned shall not thereafter be reestablished, and such structure or property shall not again be devoted to the original nonconforming use. The term abandonment shall mean the voluntary discontinuance of a use, including but not limited to an intent not to reestablish such use by the owner. Any one of the following shall constitute prima facie evidence of permanent intent to abandon, which prima facie evidence may be rebutted by the owner. And among the following sections, 2.6.2.2, one of those things is that shall constitute prima facie evidence of abandonment is intentional discontinuance of the nonconforming use for 12 consecutive months, or for a total of 18 months during any 3-year period. And it goes further, but that's the relevant portion. And so what your regulations provide on the subject of abandonment, of what in this case seems clearly to have been a use that was established before the regulations were enacted. There was some evidence presented last month to that effect. What your regulations provide is that, to paraphrase really, or to state in other words, that an owner, or in this case perhaps an applicant, may rebut the presumption that intentional discontinuance for 12 months consecutively, or a total of 18 months during any 3-year period, did not constitute abandonment. Now, all we've seen here, of course, again, to refresh, gasoline tanks were removed many years ago. They were not replaced at the time. The building was leased for other purposes. All of this is admitted in that package that was submitted by the applicant last month. Again, there was an affidavit, but it really wasn't probative of the issue of what the owner at the time had intended. But with all of that in mind, your regulations provide under a section of definitions, as you know, and under the heading of use, nonconforming, adopted July 20th, 1961, so it goes way back to the beginning. Use of a structure or land, or both, which does not conform to the applicable use regulations of these regulations, either on its effective date or as a result of subsequent amendments thereof. Any use that is permitted in a district by a valid variance or special use permit shall be considered a conforming use. Now, your regulations for the LS5 zone, and forgive me if I'm sounding like for a moment I'm making the case for the applicant, the regulations in the LS5 zone provide that a gasoline station can be allowed by special permit, and that's what's been applied for here. So the whole idea of abandonment driving toward the issue of whether a non-conforming use has been abandoned or not is really answered by the fact that the use that's been, the two uses, but in particular the gasoline station use that's being sought by the site, for this site, is permitted by special, or is allowed by special use permit, and that's what the applicant's looking for. So all this takes us back, though, to something entirely different. And that's 2.11, gasoline sales places, 2.11.2. No gasoline or diesel filling station or automotive service or repair station shall be erected within a 1,500-foot radius of any part of any lot used for these purposes. Now, I have to assume that the drafters of the regulations in 1961, or those such as yourselves in some cases who have been involved in the enactment of amendments to the regulations, mean what they say, meant what they said, or that you mean what you say where it involves you, in choosing the words and choosing the language for your regulations. You have regulations that conform to non-conforming uses, and the abandonment of non-conforming uses, which, as I've said, is not the issue here. You have instead, rather, at 2.11.2, a prohibition against the erection of a gasoline station within 1,500 feet of another. Again, I have to assume that the Commission knew the difference between the word erected and the concept of establishing a use or continuing a non-conforming use. Here, even if a non-conforming use of the property in question has been abandoned, the applicant here is proposing to establish by special use permit a gasoline station use. That's fine, but it has to comply with other applicable portions of your regulations, including the 1,500-foot radius prohibition against the erection of a gasoline station. Now, those are pretty simple words and phrases, but nevertheless, just to be clear, I did what everybody else would do when confronted with the question of what a word means. I looked it up in the dictionary. I looked it up in both an online dictionary and in something called Black's Law Dictionary, which, bless you, which Attorney Casey I know will be familiar with. And so I'd also like these definitions to be part of the record. So an ordinary definition taken right from the internet of erect, used as a verb, is to construct, for example, a building, wall, or other upright structure. Black's Law Dictionary, and I'm lucky enough to have an edition from the early 1950s, which is not too far off in time from the enactment of your zoning regulations. I think it was said in the past, maybe last month, that regulation appears to have been there right from the beginning. Erect, according to Black's Law Dictionary, within about 9 or 10 years of that same time, erect in relevant part means construct. Construct is synonymous with erect, and there's a case cited for that in another state. But then also I think we can take note that the Black's Dictionary defines erection as raising up, building, a completed building, to build, construct, to set up. Now I point this out in an effort to simplify and make clear something that's been made rather complicated as we've gone on this odyssey into the concept of abandonment and what someone intended a long time ago and what someone, why someone didn't put back the tanks and so forth, all of which is, I would posit, irrelevant. Here you have an application to build a new gas station. The application narrative, if you read through it, it talks about demolishing a gas station and in a different location, not establishing a use on the property, whether that's already been done or is being done as part of the special use permit sought, but specifically building a new gasoline station, in fact, elsewhere on the property. And I think your town planner in his report, I think, uses the word demolish also. It's a very fair read. In fact, it's a direct inference from what's not only been applied for in the narrative, but what the plans show. There's an existing condition plan that shows a gas station in one area. It's to be demolished, and a new gas station is to be built. That's what's being proposed. And so again, I hope I've simplified the issue. It's nothing to do with abandonment. The only thing being abandoned is the gas station that stands there today. It's going to be demolished, and afterward it's proposed to erect a gas station. That's what the prohibition applies directly to. The word erect means what it says. And now on that basis, or with that background, I would like to call up Mr. McNeil.
Just for everybody's information, these three experts, Mr. Batista, Mr. Temple, and Mr. McNeil, were all signed up as speakers.
Thanks, Mr. Chairman. I'm going to remain at the podium for just with Mr. McNeil, since I have a series of questions that I would like to ask him. But I would...
Excuse me, Attorney, would you be able to use the microphone when you ask those questions? I can't hear you.
Oh, absolutely. I am sorry, sir, and I will we'll try to make sure that we get in as close as we can. Again, in case the recorder didn't pick it up, I have with me Mr. John McNeil. I'm going to ask him several questions, which relate to specifically the matter of the requirement in 2.11.2 that gas stations be separated by, that no gas station may be erected within 1,500 feet of another. And specifically also to my point that my client is in the gasoline station business itself, I would like to ask Mr. McNeil, first of all, to identify himself and to state what he does for a living in connection with with my client, Alden Associates Limited Partnership.
Do I have access to that piano? My name's John McNeil. I'm with Alden Associates. I've been with these guys for 41 years. And we've owned that facility. That's one of our many facilities. And I actually worked for Lehigh Oil 2 years before that. I'm the Director of Facilities and Construction. Under my heading, all maintenance, construction, design, and environmental falls under my purview. So I've been in this business for a long time, and this 60 South Broad Street is one of ours that we recently did some work at to bring it up to snuff. I'd be glad to answer any questions that Mr. Chase has, rather than ramble on, because I know you guys probably want to get out of here.
I'm sure that's true, Mr. McNeil, and in the context of the extensive work history you describe with Alden Associates Limited Partnership, do you work closely with the owners of that company and with other persons in business decision-making authority?
Directly.
Mr. McNeil, with regard to the location at 60 South Broad Street that your employer owns and operates, were you, your company, faced with the need at a particular point in time to do an upgrade to the facilities that are located
yes,
there?
as some of you may know, underground storage tanks have a life expectancy of 30 years. And they were facing replacement age, so a decision had to be made to continue operating a gasoline station there or to change it to another business. At the time, fully aware of the age of the tanks, we made the financial decision to replace the tanks, piping, and dispensers in 2018.
So faced with that decision, Mr. McNeil, well, let me ask first, would it be fair to say that that work done in 2018 involved a substantial expenditure and investment in that property?
Significantly, I have the numbers if that's something you want to know.
Can you give a ballpark?
300,000.
$300,000. And to, just to make clear something I believe you said in answer to one of my first questions, your company made a decision to make that investment in that facility, and otherwise, if it hadn't performed that upgrade work, it would not be able to continue in business at that facility.
Correct.
Is that right?
Before we make an expenditure like that, we analyze the property, and that's not one of our premier properties. It's definitely one of the weaker properties, so that investment is analyzed before we expend the capital based on the market in the area, and so we decided to move forward with the property rather than change the use.
Now, in that decision, Mr. McNeil, to move forward with that costly investment in the property, rather than, you said, change the use, I would say
Sell it,
give up its use as a gas station facility. In connection with that decision you've referred to, or let me ask generally, is your company and you in connection with your company faced with decisions like that regularly at other locations also?
Yes.
And as part of the business analysis, whether to make that kind of investment to continue on with business at a particular facility, do the things that are taken into consideration include the applicable zoning regulations at the area in question?
Yes.
And so were you and therefore Alden Associates aware that the Stonington zoning regulations provide, as I said at section 2.11.2, that no gasoline or diesel filling station or automotive service or repair station shall be erected within a 1,500-foot radius of any part of any lot used for these purposes?
We were.
And so your decision to make the investment at 60 South Broad Street was based on your understanding and awareness of the regulations that this commission has enacted and published and made known to members of the public?
Yeah. Yes.
Was the 1,500-foot prohibition a major part of your decision to make your investment at this property?
Due to the marginal property, yes, it was.
And you've already stated, Mr. McNeil, if I'm correct, that you made this decision, or rather Alden Associates made this decision at the time to its financial detriment. Is that correct?
Yes.
In other words, it did not, no one was forcing it to spend that $300,000 and make the upgrade. It had the choice to proceed or not.
Yes, it did.
Now, Mr. McNeil, do you believe that if this commission were to now simply overlook its own regulations and allow the erection of a gas station within 1,500 feet of your company's facility at 60 South Broad Street, is it your opinion that Alden Associates would be subjected to a substantial business loss through such competition?
That's why we're here. The answer is yes.
Thank you for being candid in that respect.
Attorney Chase,
Yes.
we're not going to overlook any regulations, so I object to that statement.
Oh, I apologize.
If this commission were to simply overlook the zoning regulations,
Yeah.
we're not going to overlook the zoning regulations.
I-
Please give us more credit than that. We're all here as volunteers to listen to valid arguments on both sides of the question, but the insinuation that we're simply going to overlook a regulation, I take exception.
Mr. Chair, I would like to perhaps dial it back and explain.
You don't have to.
No,
I'd like you to move forward.
Yes.
But
in
please,
going through these,
that sort of insinuation has a negative overtone that is cast on every one of these volunteers that's here, that's trying to do the right thing.
If I may, Mr. Chairman, I think what Attorney Chase and Attorney John Casey, for the record, what I think he's trying to do is show that his client has some sort of legal standing to take an appeal, which it's not an issue to this commission. It's totally unrelated That's something you might have to prove to a court if you were to grant this application, but to take up your time, I don't know, try to get some sympathy. I mean, we're not comparing his client's gas station.
I understand, you can take this up in rebuttal, and I appreciate it. You know,
Mr. Chair,
it's just, the only point I'm making is the insinuation that anyone on this board would overlook something intentionally is objectionable.
It's not my, it was not my intention to
I
insinuate
understand
any
that,
such
okay.
thing.
Thank you for that.
And
You may
rather,
proceed, sir.
and rather the questions that I've taken my witness through are those questions that have been examined by.
I'll take you at your word that you didn't mean that by using the word overlook.
I certainly did not.
Okay,
I
thank
assure
you.
every member of the commission, seated, alternate, and every staff member that that was not my
Thank you
intention.
kindly.
Yes, sir, and I appreciate you bringing that up because I would not want that concern to persist. Mr. McNeil, you relied on the commission's regulations, on the town regulations in making your business decision to invest in your property, and it would be to your detriment if the applicant here were allowed to proceed despite the requirement of 1,500 feet separation for the erection of a new gasoline station from any other one. Is that your testimony?
It is.
Thanks, Mr. McNeil. I have no further questions along those lines, except I will ask that given your background in facilities and facilities management and so forth, would you have any further comment beyond what's been expressed by Mr. Temple already concerning the proposed delivery of gasoline between the hours of midnight and 6 a.m.?
Sure.
An operation of the station between 6
I'll be
a.m. and
brief.
12 midnight.
I'll be very brief. But
Thank
we have used many haulers over the years. Many of them, most of them, manage themselves. They watch the delivery. They watch the volumes electronically through tank, measurement process that they can gain access online. So they know when the tanks need to be filled or they're getting low. They certainly could fuel them at night, but they prefer obviously to work during the day like all of us, but they start very early and they work late. It's hard to manage them to tell them on a particular time, but I just will add to Mark Temple's testimony about lighting. If the facility's closed, it's just the operator of the truck that's going to be there alone while he's transferring the fuel. That is a risk. I mean, I think that, and also there's a way of telling if they comply, if you want to follow it, if you ever approve it. When there's a delivery made, there's an increase report that's printed out on an electronic device that measures the product. It's called an increase report. You can tell when you get a delivery, you can match it to what the bill of lading is, about if they brought the right amount of product. It's the way you tie it out to make sure you're not leaking and all kinds of stuff. So that delivery report will tell you what time the delivery occurs. So it's pretty easy to see if you want to hold their feet to the fire. Just wanted to throw that out.
Thank you, sir.
You're welcome.
Thank you, Mr. McNeil, and to cap off further something that was stated, Mr. McNeil, the questions were neither intended to do the things that a concern was raised about, nor in an attempt to elicit anyone's sympathy. Unlike, for example, the submission of petitions. My client has the same rights as any other citizen. We want to make sure that this commission is understanding that my client is being straight up with its concerns. It is a competitor in the gasoline business located right nearby. It would be competing for the same customers, for the same amount of traffic, all of which one may assume is relatively static. I know there's no specific testimony to that effect. And all that we are asking in making this presentation tonight through Mr. McNeil, Mr. Temple, and Mr. Batista is that the Commission follow its regulations, the Commission consider the evidence, that the Commission consider what we have pointed out is lacking in the presentation and in the application to render a fair decision, and certainly to take what time it feels is necessary to analyze everything that's been presented, including any necessary consultation with your attorney or anyone else. Thank you very much.
We appreciate your comments and the comments of the producers.
Thank you very much, Mr. Chairman, and others.
Chase, or
Yeah.
any of the three aspects?
Yes. Out of curiosity, when was the gas station at 60 South Broad built? Does anybody know?
I'm sorry, sir, the person seated behind me was asking me a question.
What year was the gas station you're representing built?
I'd have to put that to Mr. McNeil if he knows.
I meant to look it up on GIS, and I ran out of time.
Yeah, no, so Mr. Temple believes it was the 1960s. Mr. McNeil seems to be saying that it was some point before the 43 years began that he spent with the company. And so I guess, pardon me if I'm going too far in this response, sir, but I guess the question is, which came first?
No, I just asked what year your station was built.
You
That's
know,
all.
was something done? Frankly, if both gas stations were in existence before the regulations,
Yeah.
then
I think that's
both were in existence before the regulations.
Uh-huh.
But again, we're not talking about establishing uses. We're talking about erecting gasoline stations, where it's proposed to demolish this one and erect a new one.
We do have 1982 as the year built on the GIS.
I was wondering, I
For
was going to
60.
look that up. You did. Thank you.
But to the extent that that's a date that comes from assessor's information, I'm not sure how reliable.
I mean, we'd
it
have
is.
to go back and pull the original permit, but if the assessor's information's there, I mean, that's pretty much correct within the year. So we would just
Yeah.
have to pull the relevant
Yeah.
zoning and building permits to substantiate.
I can tell you that David Savin, the guy that I work for, bought the facility, all the facilities in '82. That station was there, and I worked for Lehigh before that for 2 years. That station was there then. So '82 is incorrect. I'm not sure how much it goes back, but it's older than that.
I mean, to the extent that the question of when it was first erected at 60 South Broad Street is relevant to any kind of determination, we'd certainly be glad to research that further. I know the town planner has indicated that he has some abilities to look for permits and so forth. And I think that, we could certainly do that. We're not prepared to answer that question in a meaningful way tonight, unfortunately.
Thank you, sir.
I just say that we can pull it, but that, I don't know if that information, the commission deems that information relevant to this, because it's not the site under question tonight. But we can pull that information if needed.
It would be interesting to know.
I did want to question the notion that there would have to be a separate special use permit for the retail that goes along with a special use for the gas station. Is that a standard practice that any gas station with a retail store pulls 2 special use permits?
I think that's a question for Clifton and probably a question for the zoning officer too, right?
That'd probably be, yeah, that'd be a question of, going back, and one of the first things we do is just go and check the definitions and the current regulations.
Yeah.
And then we'd go back and look at past precedent of previous gas stations applied for and what format did they apply under. And so that'd be more of a question for the zoning enforcement officer. Can't answer it right now. I think most of us are cognizant of the fact that the convenience store and gas station uses are colloquially synonymous, and very rarely are they not. So we'd have to look at the intent and then past precedent.
Sure. And then I just had one other question that really goes back to square one on this, and our plan of action for the evening. I understand that this was the last day we could continue this public hearing to, is that correct?
Without extension.
Oh, without extension, okay.
It can be extended tonight, and basically we would act as the commission making the decision to extend that public hearing.
Okay.
I think we answered our own question. It was.
I think so. I wasn't sure if I was
Appreciate
here for
it.
that.
Thank you, sir.
Thank you.
So if there are no further questions, does the applicant desire rebuttal time?
What about public comment?
I went through everybody on the list, so
Well, I didn't sign up because I didn't know I had to, but.
by all means, Carleen, please, far from me to overlook that.
That's okay.
If you could just state your name, we all know it, but.
For the record, my name is Carleen Donnarummo. My husband and I own the property across the street, and that gives me legal standing in this procedure. I would like to ask Mr. Hurlbert to come up here and show the commission about the storm drains he's talking about on Route 1. We are blessed with 2, one on either side of our property, and the water's supposed to go that way into the wetlands, and I want to be sure, when he testified tonight and said that his curbing was going to push the water down to a catch basin, I want to know which catch basin it's going into.
Good question.
Thank you.
I'm sure they'll be anxious to, is there anyone else that desires to speak in either favor or opposition? Yes, sir.
I signed up.
Okay.
My name is Charles Caldwell, and I am in opposition to this gas station. Earlier this evening, there was a public poll that was presented, 34 people in favor of the gas station. I'd be curious how many of those people knew that, well, I'd be curious in what section of town they live in. Most of the population of Pawcatuck is east of this gas station. I'd be curious to know if they knew that they'd either have to walk there or take a left or drive down to the high school and turn around and come back and take a right into the gas station. The traffic, which brings me to traffic, the traffic is horrendous on Route 1 in the summer. I live right next to this gas station. I watched it all weekend long. It was steady all Friday, Saturday, Sunday. So traffic is horrendous. I can foresee backups. I can also foresee people taking left-hand turns out of this station, even though there's going to be signs everywhere, supposedly. People are not conditioned in this area to pull into one station, to pull in on the right and pull out on the right. Like, I don't see it anywhere really in southeastern Connecticut. It may be happening. I can't think of anything off the top of my head, and I've thought about it for a couple days. So, I just envision accidents. I envision truckers maybe not taking a right because they've got to get in for whatever reason. Even though you're supposed to, people don't always do what they're supposed to do. That's just the truth. Mr. Kemple brought up some points tonight about the wetlands, which I found alarming, just based on his expertise in that industry and what I've seen and I've witnessed in my own ignorance, not really knowing much, but just what I see as a human being watching. The amount of water that's going to come down Route 1, there are no drains. You've got almost a half mile, maybe a third of a mile stretch from the top of that hill coming down. I mean, it can be an inch or 2 inches of water, a river of water. I heard there's going to be a berm off on the side and water is going to be redirected. Not with that much water coming down. So that's concerning to me. Also, the water's going to you got stormwater runoff into the wetlands. Everything's jammed, pushed back far into the wetlands or in that area. Wetlands is not very far away from where all the gas is. So that's alarming to me. I also live, as I mentioned, I live next door to the station. When I moved in 2006, there was a gas station there. Went out of business a year or two later. The pumps have all been taken out. They boarded up the bays where they had the mom and pop, where you fix your tire and stuff, and there's no gas station there. There was a roofing company there last. They had an office, and then where the one or two bays where that used to be in there was like their workshop area where they get their roofing and everything to order. So there's been no gas station there for a while. It is abandoned as far as I'm concerned. So that's all I have to say.
Thank you very much, Mr. Paul. Anyone else who desires to speak either for or against or has general comments on this application? Yes, sir.
Hi, dear Commission. This is Ahmed Chaudhary, Jannat LLC. The only issue we have with this property is the next door neighbors. That's the only issue. We are a competitive company. We just built a nice station in North Stonington at the Rotary. We have a wetlands. We meet all the requirements. We meet everything what the town requires. You decided either my engineer is wrong or their engineer is right. You have to cross the line. If you continue hearing next month, he's gonna bring 100 pages again to stop us. That's all matters. I think a repair shop is useless compared to convenience store. It's a nice facility. People come in the convenience store, buy gas, buy candy, buy soda, and they leave. We are not harm to the neighbor. They always gonna be my neighbors. Regardless, I won't give up. I won't sell my property. It's not gonna happen. I'm gonna do best we can to work with the commission. We address everything. We spent 3 years in this application, and these people keep coming back, stopping me. And they're hitting hard on me. We meet the regulation. This always gas station. I've been living 30 years in Pawcatuck. I own Route 2 convenience store, the 380 Liberty Street. Here, town people loves me. I'm sure when I build my gas station, these neighbors will come to my gas station. Not going next piece of shit gas station next door. Oh, I'm sorry. Sorry about that. My kids won't even go to that gas station.
This is a process where people get to come and make thoughtful comments.
Yeah.
And
sorry.
the commission sorts. I understand.
Second,
But please.
Sorry, I won't use the bad word.
Only proper discourse.
Gotcha.
Thank you.
Gas delivery, I have a bunch of station. I own 30 station. Midnight delivery, no issue. No single issue in any of my property. Other than that, thank you very much. All set. Thank you.
Thank you very much for your comments, sir. Could you just sign the, so we have your name properly? Thank you very much, sir.
Mr. Chair, begging your indulgence, John Chase, under the, I guess.
Sir, we'll give you time for a rebuttal, okay?
No, I'm not intending to rebut. I'm sure Mr. Chowdhury's comment speaks for itself. I did have one last thing I wanted to submit for the record, because it relates to something.
Please proceed.
Last month as part of the applicant's presentation. The members may recall a discussion, whether a colloquy or a presentation last month, in which Attorney Casey addressed the issue of location approvals under Section 14-321 of the general statutes. And he indicated that he had discussed the matter with the town planner, and they concluded among themselves that this proceeding today would constitute, or this proceeding now would constitute such a process for which the legislature is provided separately under section 14-321. And I only want to follow that up with a copy that anyone can obtain online of the, and I'd ask that that be made an exhibit also, a copy that anyone can obtain online of the application for a retail gasoline dealer license under Title 14 of the general statutes. And on page 4, there is a section that says zoning approval for gasoline station. And there's an area for the signature of the chairman of the zoning board or other town or city official that says, underneath a section that says, this is to certify that after proof of notice as required and due hearing held under the provisions of section 14-321 of the general statutes, I or we have approved the location of this retail gasoline. I think the word station is omitted from the end of that paragraph. Now, we're not here to, I don't believe, engage in a discussion of the history of section 14-321 and how it may have changed over time, whether and what's here is consistent with the statute or not. We've already seen it at least omits one word on the end. I think that's pretty clear. But I'm pointing out that in order for Mr. Chowdhury's company or Mr. Chowdhury to apply for his license, in theory, to sell gasoline as a retail dealer at this location, someone, you, Mr. Chairman, or someone is going to need to certify that a hearing was held under the provisions of section 14-321 of the general statutes and that you've approved this location for that purpose. I see nothing in the notice of the hearing that's currently open, nothing in the application, nothing in the publication of notice that says anything about 14-321. So I would simply, in following up on those comments made last week, would urge that you exercise caution in making a certification in that regard, simply on the basis that you've held a different proceeding last month tonight, and concluding wherever, and that constitutes the statutory certification required. Thank you very much.
Thank you, Mr. Chairman. Again, for the record, John Casey for the applicant. And I'll make a brief rebuttal, but then I'd like to confer with my client and our engineer. I was kind of afraid this was going to happen. We were all here a month ago. We have a letter that's dated more than a month ago with a number of technical comments, which I think, I'm not the engineer, Kyle's the engineer. He may have been able to tick those off in his head as we listened tonight. I can't do that. I was able to tick off the legal arguments as they were presented, and it was all fast and furious and a bit jumbled. But I know when I hear Attorney Chase tell you, for example, on the issue of a non-conforming use, and he's pointing to your regulations, and he's saying, oh, they have a time limit in your regulation. He knows that the statute specifically says you can't have a regulation that stops or prohibits the continuance of a non-conforming use based on an arbitrary time limit. He should know that. So he's making his argument on behalf of his client saying, well, look at your regulation. I know in my head that's wrong. And the issue of non-conforming use is important because they want to use the 1,500-foot separation distance so to put you in a corner and say, oh, you can't even permit this. But you can't apply a regulation to a non-conforming use that existed prior to the enactment of the regulation. The evidence you have before you that was submitted last month was that there's been a gas station at this site since the 1950s. Now, it is an interesting question. When was their gas station put in, right? It's an interesting question because we know that the 1,500-foot rule was, according to your regulations, implemented in the early 60s. Did they get to put theirs in, even though it wasn't within 1,500 feet? I don't know. We're not here to fight over that. But for purposes of this application, if you have a non-conforming use that everything that's been presented to you, information from your planner, information from your attorney, information in the record from the prior owner saying there was no intent to abandon, and a statute that says even discontinuance of a use isn't prima facie evidence of abandonment. There has to be more. They did take the tanks out. You heard why they had to take the tanks out. All the tanks had to come out. But that doesn't mean, and there's a case, when you take the tanks out of a gas station, that in and of itself, our Supreme Court has said, is not evidence of an intent to abandon. That was a requirement under an environmental law. And there was never any outright, it's not like, and then when they rented it to the roofing company, I'm speculating here, but you've heard a lot of speculation already tonight, they didn't irretrievably prevent this location from being a gas station again. And so the intent to abandon was, there's no evidence of it. And that's what you have to do. We don't have to prove a negative. The use was there, it was established. Mr. McNeil acknowledges there was a gas station there when he worked there. The neighbor acknowledges there was a gas station. It was there. So that the issue on abandonment and the 1,500-foot distance is significant because you can't apply it. Our position is you can't apply it to a pre-existing non-conforming use. So that's why that's important. And to get back to my point, I know that's the law. It's written into the statute. It's important here. It's important information that you should know regarding how the law works. Also, in regard to the issue about the location, yes, that application says something about a hearing, but that's not what the statute says. The statute says nothing about a hearing. It says a person who desires to obtain a license for the sale of gasoline or any other product under the provisions of section 14.319 shall first obtain and present to the commissioner a certificate of approval of the location for which such license is desired. It just says it shall be obtained from the zoning commission, planning and zoning commission, or local authority of the town. I don't see the word hearing in the statute. To a certain extent, this is a separate issue. But I wanted to clarify it with your planner, like what else would we need to do? We can come back and do it again. I think that's a waste of time. Because as your planner told me, there's no other separate application provision. There is for repairers and dealers going to the Zoning Board of Appeals. There's nothing else in your regulations about a separate process under the statute, state statute, for gas stations. So it was his opinion that this is the process for that. So I think, if you don't mind, if we could take a brief recess, I think we could then give the commission some better idea about where this is all going to go.
How does the commission feel about 5-minute recess? Motion? All in favor? Anyone opposed?
Thank you.
For being here at
9. Thank you, Mr. Chairman. Again, for the record, John Casey of Robinson and Cole for the applicant. you've heard a lot tonight. We've heard a lot tonight, for the first time, unfortunately. But it's still our client's intention to see the hearing closed this evening. I'd like to ask Kyle Hobart to come back up and to respond to the comments that were provided. And we do this because we know the site was designed by a reputable engineering company. It was reviewed by your town engineer, who made some comments, and all those comments were addressed. As Kyle will explain to the best of his ability, because we're kind of doing this on the fly, we feel the remainder of the comments are based mainly on speculation. You heard talk about lighting, where the tanker trucks are going to pull in, whether they're really going to do their deliveries between midnight and 6 in the morning. When you heard Ahmed say he has 30 gas stations, that's when they make the deliveries. He knows how gas is delivered. We wouldn't have made that condition or suggested that condition if we didn't think it was something that could be complied with. We wouldn't have had a traffic engineer say that the site was safe for right-hand turns in and out if that wasn't the case. Our people knew there was a sign there. Our people knew there was vegetation proposed there. You know, I've been to a lot of zoning hearings. I've heard a lot of people say, well, what about this and what about that? Well, yeah, we can always think of some nightmare scenario where something's going to go wrong. Someone's going to park a box truck in the parking space, and that's going to, I don't know what, how is it going to be there 24 hours a day, 7 days a week, blocking sight lines? I don't think so. This is a convenience store. People are in and out. We can hear nightmare scenarios about people, well, no one's going to follow the signs. We can't control that. All we can do is design a site to the best management practices, using best engineering standards. Just as I assume the other people you heard from tonight do when they design a site. And so that's why we would like to just keep this moving forward. Before Kyle gets up here, I'll mention like I said, there's a lot. This idea of parking, shared parking, 2 special permit uses. I would say this. The way your regulations are written, the gas station is a special permit use. So you have to get a special permit use for it. Your regulations also allow accessory uses consistent with the primary use. Convenience stores are typically considered, and your planner can go back and provide this to you even if the hearing closes, because you're allowed to get comments and additional information from your staff. But I would say to you that the convenience store is an accessory use to the gas station. Believe me, I'd love to do a lot of research on that, but I think for fairness to this commission, at a certain point we need to end it and go forward. But I think going forward, that's why. And I assume if Candace Palmer thought we needed 2 uses, and she's been with the town for a long time, that if an application like this came in, and she knew that it was multiple uses requiring multiple special permits, or I guess 1 special permit and 1 permit as of right, for the retail use, that would have been presented. But I think the concept is you look at the more intrusive or use, the gas station, you get the special permit for that, and the retail establishment is accessory to it. Because you'd have to, even if you didn't sell a single candy bar, you still need a place for your staff, your clerk, to be inside to handle the money. So, and the neighbors, the opponents can talk all they want about margins and how, we're really just here to sell candy bars and coffee. But the reality is you need a special permit for the gas station. and not the retail use. And I assume if we were just here for a retail use, I don't think we'd be here actually, because it's as of right use. So with that, as I said, I appreciate my comments are slightly all over the place, but I want to turn it over to Kyle at this point. He can go through in a little more orderly fashion, since we have something in writing from the engineer in response to those comments. And as I said, it's our intent to see that this be closed. I know you need our permission or request to extend the hearing. I'll be open, if someone feels very strongly about something, please let us know if you feel there's more information we need to add to the record. But you already have a lot, and we feel just kind of going back and forth over things isn't going to help you to any great extent. So with that, I'll turn it over to Kyle.
Again, Kyle Hobbert from CLA Engineers. I'll do my best to kind of go through the comment letter and address everything that I can at this time. Regarding the engineer submittal of comments on the application, the first two comments are regarding erosion and sedimentation control measures on the plans. There's a thorough erosion and sedimentation control plan. There's a narrative on the plans. The Wetland Commission has reviewed and approved the erosion and sedimentation controls, as well as the town engineer has reviewed and approved the erosion and sedimentation control measures and narratives that are on the plans. So I think that those reviews and approvals are sufficient, that the erosion and sedimentation control plan and narrative are adequate for this site. Attorney Casey addressed the third comment with regard to the shared parking and the multiple uses on the site that was brought up. Comments 4 and 5 are regarding the sight lines for the site, as well as the configuration of the entrance and exit drives for the site. I'll submit for the record, this is a copy of the letter. Which, as I mentioned previously, the only outstanding comment is to add an additional no left turn sign onto Route 1. So DOT has reviewed the stormwater management plan, the last iteration of the site plans that you have before you, and reviewed the sight lines and the driveway configurations, like I said, both into and exiting the site, and have provided no additional comment. I have no issues with the sight lines. Any of their, the sight line, the site triangle is unobstructed, as DOT would have brought up if there were obstructions within that sight line, that if it didn't meet their regulations. And they were satisfied with the configuration of the driveways as presented. The site was also reviewed again by your town engineer, and he had no issues with the configuration of the driveways. Item 6 also notes the no left turn signs. Again, this is a DOT jurisdiction, and DOT has reviewed and approved that configuration and the signage, and as I said, requested an additional no left turn sign on Route 1. Turning movements through the site, a garbage truck was mentioned. We didn't run specifically a garbage truck through the site. We did run a box truck through the site, which is similar size and configuration to a garbage truck. And there's adequate turning movement through the site to allow that vehicle, as well as the tanker truck can make it through the site. So in my opinion, a refuse vehicle, a garbage truck, would be able to access the site and access the dumpster area for removal of the refuse. Regarding interior landscaping, areas of interior landscaping aren't specifically called out on the plans, but the frontage of the building contains the 9 parking spaces, primarily at the front of the building. On each end of that parking area, there is landscape areas in there that exceed that area that I would consider as interior landscaping area. And again, this site was previously served by municipal sewer, municipal water. This proposal will connect to those existing sewer and water services. The traffic engineer has reviewed the proposal. It's been reviewed by an original traffic engineer and is supplemented with an additional review by a second traffic engineer. Their contention is that this development will have no negative impact to the traffic on Route 1, and that the traffic entering and exit the site can do so safely. Regarding the stormwater and the stormwater management on the site, I'll first address the stormwater on Route 1. The stormwater on Route 1 will stay on Route 1 and continue running down the gutter of Route 1. Currently, as we noted, a portion of it does kind of enter the site slightly and then re-enter Route 1. This water will stay in Route 1 and continue to flow as it has down Route 1 from the east. It'll stay in the gutter line. It does not cross the street. No, Route 1 is crowned and it stays in the gutter. Correct. That's correct. That's correct. Currently, the driveway, there's a small landscape island that allows some water to enter the site. Kind of. Correct. But it does re-enter Route 1 just downstream of that existing landscape island, and will continue. Correct, and does not create any additional flow, to Route 1. It's the existing flow on Route 1 will stay in Route 1. That is what will be happening. The stormwater on site is collected on a trench drain and a catch basin. The catch basin will have a hood on it to collect any floatables, papers, styrofoam cups, that type of stuff. All that stormwater is then filtered through a storm scepter unit that functions as a oil water separator. And as noted, we'll capture floatable oils in that unit. That is then discharged to the vegetated water quality basin, which provides further filtering of that stormwater prior to leaving the site at all. That vegetation will, provide, like I said, additional filtering. It's discharged through a level spreader, just a level overflow. It then flows through grass over land before even entering the edge of the wetlands. Again, the Wetland Commission has reviewed and approved the stormwater management system and the site. The town engineer has reviewed and approved the stormwater management system, for the site. And noted that it does meet the deep water quality manual requirements, as well as the guidelines of the town's MS4 guidelines. And with that, I think I've gone through pretty much all of it. If there are any questions, I'd be happy to.
I do have one quick question. I know Carleen Duano had raised a question about the runoff, and Carleen, I just wanted to ask, did his response answer your question? Oh, sure, yeah, so I just.
Carleen Donnarumma for the record. I asked Mr. Hurlbert, or I'm sorry if I'm pronouncing his name incorrectly. And his response to me was, we do not, if I'm saying this correctly, he didn't do anything about the stormwater on Route 1. And I know that there's no storm drain on his side. There's no drainage on his side. It's only on my side. So he really, I'm not sure if he answered my question. He says it's going to stay there, whatever's going there. But if it's going on his property and then off his property, then it's still going to go on Route 1. Maybe we should talk to someone about putting a storm drain in there so that it can go into the wetlands the way it's designed now. I don't know. Who do we talk to? The state? The town's not going to do it.
District, are we in District 2? Is that where we're in? Yes. District 2 has a drainage section and a drainage professional. that we look at an issue like this. That's where it would start. And if it turns into a major project, it gets bumped up to, DOT, the main office of DOT, and they initiate a project. Sometimes, especially on an old road like Route 1, the drains are grossly undersized and can't accommodate additional catch basins. So you put a catch basin in, and all it does is create a downstream flood. But I don't know if that's the case here. Thank you. I don't know if that's the case here or not. But if there isn't a catch basin, you're saying there is a catch basin.
Not on his side.
Further downstream of our site, we did not feel located.
How far down?
We did, I don't know, but as I said, we did not feel located all the drainage in the DOT.
So you don't see anything there. Okay.
Well, I don't know if it's up to you to talk to them, or me, or somebody.
It's a state highway. We have no jurisdiction. So.
Not even to ask to have it
But
looked
the
into?
town engineer has approved the drainage plan. So I assume he has looked at this.
Right, and DOT does too, as well. So this site provides no negative impact to the storm drainage.
Right.
DOT has reviewed that.
The issue of storm drainage entering the site is easy to handle with a driveway apron. The issue of where it's directed to is sort of an open-ended question that I don't think we have a reasonable answer to.
Thank you.
Just as a quick addition to that, as I noted, the stormwater from this site does not contribute to Route 1. And as I said, the DOT staff, the professional staff has reviewed the stormwater management plan and the site grading plan and drainage plan and had no issue.
That's true. Pre-development and post-development flows are exactly the same.
Correct. The flow on Route 1 is not going to change, and again, the DOT staff has reviewed that.
Understood.
Thank you.
Thank you, sir. Any further rebuttal from either of you? Does anyone have any questions on the rebuttal? No?
I just have one question about the parking. So there's 17 spots in total, and it's 16 and a half because of the convenience store? That's the...
Correct. That is what generated the parking now.
And then part of the parking is for the pumps, that is the case?
Correct.
Is that common that?
It varies town by town.
Okay.
Many towns do allow us to count these parking at once as a parking space.
Okay.
Figuring many people get gas run into the convenience store and then
Right. Okay.
Does anyone who spoke in favor or opposition wish any additional rebuttal time? Attorney Chase?
Yes, Mr. Chair, just briefly, and trying to limit it to the rebuttal that Attorney Casey had provided. But I always think in situations like this I can't remember the name of the old Charles Dickens novel where the mark of the great lawyer was the ability to turn black white and make white black. Well, what's black and white here are your regulations. Your regulations say, with regard to shared parking, that a special use permit is required where two separate uses are proposed to share the same amount of parking, the same parking spaces. It's not whether a special use permit is required for the convenience store or whether it's an accessory use. If this was an accessory use, it would not be part of the application. People don't come before you proposing to build a house, and by the way, an accessory shed is well. They have, the regulations define the two uses here separately. Retail, gasoline station. What's proposed is shared parking, those 16 and a half or 17 spaces. Your regulations say a special use permit is required in order to do that. And the other thing is black and white, or white and black, is the fact that your 1,500-foot distance requirement has nothing to do with the establishment or the continuance of a use. I've conceded that the applicant has the ability to, either by virtue of nonconformity or by virtue of the permit that's being granted here. In fact, one queries if it's solely on the basis of nonconformity, why are they even here looking for a special permit? But nevertheless, it's not a question of the use. It's a question of the distance requirement, and you know that all the time, you've seen it on this commission, sometimes there's consequences that go on to the Zoning Board of Appeals looking for relief, where someone has a nonconformity, but they're still required to comply with things like the current setback requirements, the current height requirements, things like that. If someone proposes to demolish an existing building, even if their use of a site is non-conforming, if they propose to demolish that existing building, they can't build it back any higher than the old one was, or any closer to the side property line than the old one was. You know all about that stuff. This is not a question of the continuance or even reestablishment of a use. The use proposed is gasoline station. I don't know how I could agree more with Attorney Casey in respect to that, even though he doesn't seem to think that I do. The prohibition is on the erection of a gasoline station. That's what the regulations say. Now, whether a court, in reviewing a decision that may emanate from this commission, may have something to say about that requirement or not, I don't really know where Attorney Casey may be heading with that. I know that the regulations say what they say, and all that I'm asking you to do, all my client is asking you to do, is to apply your regulations, in particular regard to that distance requirement for the erection of a gas station where it's proposed to demolish one on a different portion of the same site, and also to ensure compliance with the shared parking requirement where that's clearly proposed, and the two uses that are subject of this application and of the advertisements for the public hearing and so forth clearly speak of a gasoline station and convenience store. Maybe it's in the opposite order, I can't recall. And then obviously with regard to the technical requirements that have been raised by the engineers on all sides with regard to, or to the extent that they are addressed to requirements in your regulations, please apply your regulations. That's all we're asking. Thank you very much and have a good evening.
Just to say, Mr. Chairman and members of the commission, we feel that we've presented a complete application that's been sufficiently reviewed by your town engineer and by your planner, and you have substantial evidence before you to make a decision. If there are questions you have, the law allows you to consult with your staff following closure of the hearing. So if there's questions regarding the application of your zoning regulations, I think that's a fair topic to get input from your staff during your deliberations. And so with that, I would just ask that based on the totality of the evidence that you had before you, you close the hearing and you grant the application as it was presented. Thank you.
Anyone else wish to speak, rebuttal, or any other comments with regard to this application? Okay, one more time. Anyone else wish to speak?
Mr. Chairman, I make a motion to close the hearing.
No.
Motion has been made to close the public hearing. Is there a second?
Second.
Second has been made. Any discussion on the motion? All in favor?
Aye.
Chair votes aye. What's your pleasure on a decision this evening? We've received a lot of new information.
Mr. Chairman, I would suggest that there are a number of questions, legal questions that have been raised by both sides here that I would think the town attorney would like to have a look at. I would be curious as to his input on the 1500, on the dual use. I'm not an attorney, and I know each side's presenting their interpretation of the statute of the law. I would like someone unbiased, or as unbiased as possible, to give us, you know, an interpretation based on our regulations in the law. So I would
completely agree.
I would request that we, you know, take the next step would be to submit those kind of questions. I think we have a
Well,
list.
there's a zoning question.
A zoning?
There are a few technical issues.
Yes.
And a legal question.
Correct.
With regard to abandonment. And so those are the areas that we would need additional input from staff on.
Can we just make a list of those for the record as well, like specifically individual items?
I can say the first two specifically would be the 1500 separation. I'd like to know actually how that is specifically defined. How is it measured? Is there any case law that the town attorney may be aware of that helps us in this kind of instance? That's a little unclear to me. The dual use, that's another one I'm not too
That's the
sure.
zoning question.
With the, you know, the convenience store or gas station where the requirement for two, or one side saying you need 2 special use permits, one says you don't. I don't know the answer to that. The parking also question, I think, is something that I'd be curious if you count those spaces by the pumps as parking or not. I don't know. Those are the 3 that stick out the largest in my mind.
I'd also like to get the town attorney's opinion on the erection, construction.
Abandonment
Yes.
issue, like, right?
Yeah.
The issue of how abandonment really comes into play here.
How abandonment ties into erection
Yes.
of a new version of a pre-existing non-conforming use.
Yeah. Yeah.
Demolition and then construction.
There were a few technical issues in that report that dealt with intersectional site distance, the unresolved conduct comment, and if we have the right documentation on water and sewer approvals too. I think we,
Well, I don't know if the commission feels that the applicant answered those, but just from the report, at least, what we have is the WPCA response to this. We also we received no comment from Ledgely Health District. We received a no comment from Westerly Water Company.
okay.
We also received a recommendation of no comment from the Board of Police Commissioners regarding the traffic and signage and all that stuff. And then what was provided as an exhibit, but it's also has been in the record or in the file, is the CONDOT response saying that there was an extra sign needed. And then the only other thing that CONDOT said as part of that exhibit, which has been passed out, is that the application is denied contingent upon receiving town approval, so they can't get an encroachment permit before the town approves it.
Correct.
So that's just basically a formality's sake. But
The
that was-
standard condition.
So at least from the staff perspective, those outstanding comments have already been addressed.
Okay. That leaves the intersectional site distance issue.
And site distance, I mean.
And you're saying the CONDOT approval covers that?
I mean, I'm not a traffic engineer, but I would say that both the Board of Police Commissioners as well as CONDOT didn't bring it up, so I personally lean on their expertise when I write these reports.
Okay. I would feel more comfortable, I think, if the town engineer did take a look at that. The intersectional site distance isn't going to be looked at in a police traffic review, and CONDOT invented the whole intersectional, they didn't invent it, but they have perfected it, the whole intersectional site distance approach to intersections. And perhaps we could either check with them or to see if they did look at it, or check with the town engineer. It sounded like there were some fairly substantive obstacles in the way of the drivers, in the path of the driver's eye, that would obstruct intersectional sight distance. And I just feel more comfortable if he took one more look at that. Other than that, I'm comfortable with the fact that Water and Sewer has commented, and the CONDOT memo deals with the unresolved CONDOT comment issue. So it's just intersectional sight distance.
Any other burning questions?
Any other questions for Clifton? Okay. I think that's the extent to which we can handle that item. There's no other business on the agenda for tonight, so I think the appropriate motion is in
Mr.
order.
Chairman, I think we need to move to table the application to the next meeting
For a decision.
for a decision.
Okay, so there's a motion to table. Is there a second? All in favor?
Aye.
Aye.
Anyone opposed? Motion passes.
And Mr. Chairman, I make a motion to adjourn this meeting.
Second the motion.
Motion's been made and seconded to adjourn. Any discussion? All in favor?
Aye.